What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Sketchy! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. All right, I have got a Judge Simpson landlord tenant case. This is part two. I will link part one in the description. This is the case where a tenant was locked out potentially illegally, and the landlord might have to cough up some money for this, and it's kind of sounding like he's going to. Judge Simpson's not happy with this landlord. You're about to find out why. Quick warning: the first, I think, 5 minutes of this hearing, Judge Simpson had it on mute. Don't think he did that intentionally, but we do get the bulk of it, and I think we can understand what's going on. So just had to throw that warning out there. It's not my fault that we're kind of coming in a few minutes after it starts. Blame it on Judge Simpson. I probably shouldn't say that because he'll send Mr. Allen after me. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
I see this, but this doesn't even make any sense to me, Mr. McLaughlin. I'll be honest with you. How much was his monthly rent?
510.
So where's the 400 come from? Where's that number come from?
Okay, he, on the 20th, he left me a voicemail saying he wanted to move out that day on the 20th, as long as he got his security deposit back. I responded that his security deposit at that time was down to $245, that I'd kick in some of my own money, making it even $400, and he accepted that.
You can understand the frustration on Judge Simpson's face right now. What does he mean the security deposit is down at 245? That's not how security deposits work. Judge Simpson's about to go at him about this. Yeah, you don't just deduct from a security deposit. That's not, you can't just use that to pay late rent. That's not how it works. And yeah, just look at Judge Simpson.
Not to complicate things further, Your Honor, but Mr. Daniels does deny also being that 734-221 class 45 number.
Denies what?
He denies that that's his phone number. The text and the calls allegedly sent to that number.
Yes, sir.
That's the phone number. I received a voicemail from him saying he wanted to move out that day, as long as he got his security deposit back. That's the previous exhibit.
Can I ask a question on the? How much?
All right, real quick, just remember, because Judge is trying to put together his words right now, but just remember that comment. It doesn't come back up. I think it's important for us to remember for part three, because there will be a part three next week. So the defendant's denying that the number that was called to the landlord to say he wants to move out is even his number. This landlord, just got to remember that, and I'll bring that back up here in a few minutes.
Exhibit 2. Explain that to me. What you're saying there.
Basically, what this says is He started out with a $765 security deposit. He only made a partial payment on his June rent and no payments on his July rent. So by July 20th, when he said he wanted to move out, he only had $245 left on his security deposit, and I agreed to bump it up to $400.
So how is his security deposit being deducted before he's vacated? That was a question.
The 245 was arrived at by how much he didn't pay. The 765 is how much he didn't pay for his June rent and a prorated $17.
He hasn't vacated the premises. How are you deducting from his security deposit?
That number I arrived at
Not my question.
is assuming he vacated.
Listen, Mr. McLaughlin, to my question. He has a security deposit. He hasn't, as of the time I'm looking at this calculation, vacated the premises. How are you deducting from his security deposit?
On a prorated daily basis. I don't understand your question, I guess.
Okay, that's because you don't understand the Security Deposit Act. How are you deducting from his security deposit? That's the tenant's money that you are holding. You do understand that.
Yeah.
So how are you deducting from his security deposit prior to his vacating the premises?
Yeah, I still don't understand your question. That would be the deduction, how much? I understand, 765 was his money. But then he.
So how are you taking it before he's vacated the premises?
I guess I can't answer your question.
Oh, no, I think you can answer it. I don't think you like your answer. Because I think you know you can't. So Mr. McLaughlin, you've been in this.
All right, so the plot thickens a little bit. Now, in part one, the tenant was saying he's all caught up on rent, so there's no reason to be locked out, which is true. You can't lock him out. But it kind of sounds like the tenant agreed to let him take out of his security deposit, or maybe the landlord said, I'll take this rent out of your security deposit. You can't do that. So landlord went about it all wrong. He shouldn't have accepted any, he shouldn't have done that, and he should have filed his eviction when he was late for his rent, not taking it out of the security deposit. Now that's just me assuming. I don't know. I feel really bad for this tenant. I think he's being screwed, and this landlord obviously doesn't know what he's doing. But that being said, there may have been an agreement there, but I still don't think that flies. Even if the tenant says you can take it out of my security deposit, I don't think you're allowed to do that. I'm actually just going to say you can't.
Important enough. If this were your agreement, which I understand Mr. Daniels is denying, why wouldn't you have just waited 5 days, come to court, stated the agreement, and then resolved it that way? If indeed this was the agreement.
That would have been an option too. In retrospect, maybe I should have done that, but he told me he wanted to move out that day on the 20th. And I wanted to honor what he wanted to do.
Okay. Is there somebody living in the premises now?
In the other rooms, yeah.
Well, let me ask this. So he's just not on the premises, right?
Right.
Everything else is the same as before he left.
Mhm.
His stuff is still in his room.
And we have an agreement that he can come get it anytime he wants.
This makes no sense to me. None. Handwriting expert, but I'm also. You have a copy in front of you of your exhibit 5? I think it's 5 or maybe 3. It says 5, the agreement.
Yes.
You're telling the court that's Mr. Daniel's signature?
Me?
Let me, hold on. Were you there when he signed it?
Absolutely.
Put him under oath, Mr.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help
Yes.
you God? State your name.
Pat McLaughlin.
Put Mr. Daniels under oath.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. State your name.
Daryl Daniels. I mean, when he signed this, he was standing up. So maybe that's.
Okay, and so what's that mean?
That means it might be illegible, but he did sign it.
That is probably, the most what's the right word to use here? Because I don't like using the word crazy, but that's a crazy defense. He was standing up. Come on. Could your signature change a little bit if you were sitting up or you're standing down? I guess. I mean, maybe your L's aren't as clean, but yeah, it's not a completely different signature, man. Also, this is why I said remember that phone call. He's the landlord submitted some evidence that he called him. He's like, no, and the tenant's like, no, that's not my number. He never called me. This conversation didn't happen. This is so bizarre. Yeah, sketchy ass landlord.
Which copy? You have the agreement in front of you, a copy of the agreement that's signed?
Yeah.
That you say was signed? That signature.
Yeah, I think they're different.
Oh, they're not just different. Those aren't by the same person.
Oh, yes, they are.
Oh, no, they're not.
I have 2 other witnesses who can come here and tell.
All right, then we're gonna have a hearing. You're gonna bring them in here. Everybody's gonna be put under oath, because I'm gonna tell you something, Mr. McLaughlin. This makes no sense whatsoever. That you are headed to court. You file an action, I think, on July 8th. You are headed to court. 5 days before that, somebody, or maybe even before that point in time, somebody gives $400, then gives another $400. The stuff isn't moved out of the unit and the locks are changed. Outside of that, there is then this bizarre deduction from a tenant security deposit, which apparently has occurred prior to him vacating the premises.
No,
Yes.
it's simultaneous with when he vacated.
No, but you're deducting before then.
No, but the money isn't exchanging hands until he's sick.
Okay. So here's what we're gonna do. You're gonna find me a date that we can do this. When are these other people gonna be available? These witnesses?
John Addis is available any day. Frank Temple is available any day except Friday. Well, Friday he's available, but he works later.
Well, I'll tell you what, I'm just gonna set it and then you gotta make sure they're here. Cause I mean, I'm not gonna work around everybody's schedule. Because it's gonna be your. And I'm gonna suggest to you, Mr. McLaughlin, based on what I'm looking at, you might want to get an attorney. Because for each day he's locked out of those premises, that by statute under the lockout statute is $200 a day that you would owe him if I find that there's been an illegal lockout. Outside of that, because now he also has counsel, you could be liable for his attorney fees. Now, granted, one might say, so we can just skip over this argument, that since Mr. Henry is from legal services, that and he hasn't paid anything, you wouldn't be liable for any attorney fees. Not the way that works. He gets paid at the rate that an attorney in private practice would get paid, and that's what you would owe. If it's found that you violated that statute. So as I count it, right now, if it turns out, absent the other statutes that certainly council's aware of that could apply to this, just on the lockout, you're at $2,800 right at this point. And that doesn't include the.
August 6th at 9 a.m.
So I'll set a hearing. That'd be enough time for you to get counsel if you want to get counsel, Mr. McLaughlin?
I didn't hear the date.
August 6th, Tuesday.
It's a Tuesday? Yeah.
This upcoming Tuesday,
9 o'clock, that's fine.
August 6th,
Your Honor,
2024, 9 a.m. Yes.
if I may, would Mr. Daniels be allowed back in the premises until then? He has been being housed by community mental health, which I do have the receipts for here.
Well, yeah. Oh, that reminds me of something. Because I was informed that he was being housed by others. That is an incidental damage also, so that any housing expenses they have would also be included and are not part of that 28. But go ahead, Mr. Henry. I'm sorry, I didn't mean to interrupt.
No worries. In addition to that, I believe we have someone from community mental health here. I believe they aren't able to house him further than today.
No.
I'll let him in. I have no problem.
When is he going to get the keys so that we don't?
Right now.
You got them with you?
I do, but I have to check which one fits the front door, so I'd have to go back. I could meet him there.
Why don't we do it this way? Because I just don't have a good feeling. Why don't you go get the key that fits, come back with the key, so that I can watch it being exchanged and given to Mr. Dan.
Sure.
So I guess technically I'll pass the matter until.
Because I put in the accounts yesterday, I don't have all the court filings, but I've got a copy of all that.
Dollar paid. And
We can address that.
sir,
Yes, sir.
sir, I'm not assuming, I am assuming nothing at this point. Mr. Henry, we will take care of you on that. Okay, thank you.
Thank you, Your Honor.
You're welcome.
All right, we're gonna fast forward till the time that he recalls this case. Again, not taking back my comment about he's a sketchy landlord. I will not. This does not make sense. And but as the tenant, would you want to go back? I understand his clothes, all his belongings, even his medication are there. That and he wanted to get back in the premises to grab that stuff. And he may not have anywhere to go right now, but I don't know. I wouldn't feel safe living with this sketchy landlord. I don't know the living situation. Part of me thinks it's like you know what? I don't know. I'm not going to speculate, but yeah, I don't know. I don't like this at all. All right, I'm gonna let this video play out. You guys are all awesome. Thank you for hanging out. Thank you for watching. Make sure you hit that like button if you haven't already. Until next time, bye.
All right, so which one, that was a recall, which, oh no, McLaughlin, did I give you the file, McLaughlin?
Yes.
Yeah. All right, court recalls the case of McLaughlin versus Daniels. All right, on this one, you can just stay right there.
Okay, honestly, I know I just said I would let this play out, but I'm gonna say one last thing. Say you're a sketchy landlord without being a sketchy landlord, without saying you're a sketchy landlord. Show up to court in shorts. Okay, I'm out.
Did you get it? Where's the key? All right, Mr. Henry, can you get the key from Mr. McLaughlin? All right, that's the key to the premises.
If I may, Your Honor, my two witnesses will be here on Tuesday. I have a third witness that is going to hopefully persuade you that
Who's the third witness?
it's a video I have on my cell phone. Can I bring in my cell phone on Tuesday?
You can bring it in. Okay. All right, thank you. We'll see everybody on Tuesday. And the gentleman from CMH, could we make sure to have, what CMH has paid out in some form? Yeah. Okay. All right, fantastic. Thank you.